Ladies and gentlemen, the question I've been asked to address for you is the following. How should a contracting authority approach a tender if it knows, based on experience that it has, that the tender is abnormally low? Now, a very specific question. The question, therefore, is not how should a contracting authority approach a tender if it suspects that a tender is abnormally low. The question really is how should a contracting authority approach a tender if it knows that the tender is abnormally low. One might ask the question, how does the contracting authority knows that the price is abnormally low? Because if you go and look at the directive does not provide a definition of what is an abnormally low. So does that mean that the contracting authority has a discretion to decide whether something is abnormally low or not? The answer is yes. The contracting authority has a discretion. Absent a manifest error, the court will not intervene. Case law has been strong on the matter, and case law has specified that the court will not trespass on the jurisdiction that has been given to the contracting authority to exercise a broad discretion judgment on the matter. The court does not want to be embroiled in any assessment or finding out if a contracting authority, if a tender is abnormally low or not. Must the contracting authority disqualify a tender if it is satisfied or knows that the tender is abnormally low? The answer is in Article 69 of the Classic Directive or 84 of the Utilities Directive. It is said that it is a codification of all issues around abnormally low tenders. So we have to go and look at that article. So if I repeat the question, must a contracting authority disqualify a tender if it is satisfied that the tender is abnormally low? The answer is yes, if. Yes, if the contracting authority has established that it is abnormally low because the tender fails to comply with the provisions of social, environmental, and labor issues. In that situation, the contracting authority must reject the tender. It's explicitly stated in Article 69.3, paragraph 2, exactly the same in Article 84.3, paragraph 2, and I read, the contracting authority shall reject the tenderer where they have established that the tender is abnormally low because it does not comply with applicable obligations referred to in Article 18.2. 18.2 is the article that specifies what you should not breach is social, economical, or labor law. Recital 40 is also interesting. Recital 40 tells us that the control, later on it refers to it as the necessary verification, the control of the observance of environmental, social, and labor law should be performed at the relevant stages of the procurement process. So very strong point, very strong guidelines on that. But should the contracting authority disqualify a tender if it is abnormally low for other reasons, not based on social, environmental, and labor law breaches, other reasons? For example, the tenderer tells you, I have purposely given you a very good price because I want to break into that market. So I've been very aggressive at it. Is that a reason for you to reject a tender? The answer is there is no obligation on the contracting authority to reject a tender in such a situation if it is satisfied with the reply it has received. Does the contracting authority have, it's all about questions, anything to do with abnormally low is about questions. Does the contracting authority have to a general duty to investigate low tenders? I told you, Article 69 deals with the case, so let's have a look at what Article 69 says. And it's very clear. The contracting authority shall require economic operators to explain the price where the tenders appears to be abnormally low. This suggests, and it seems to be very, very clear, that a contracting authority must investigate, that there is a mandatory duty to investigate. And if the contracting authority fails to investigate, it breaches public procurement law. That's what we would assume when we read Article 69.1. This is also precisely what one disgruntled tenderer told the NHS, and the case is the SRCL Limited versus the NHS, whereby the disgruntled tenderer said, well, this is all about a waste contract, and the person that won the contract, a company called HES, that company had provided a abnormally low tender, or at least appears to be an abnormally low tender, and the NHS did not investigate. That was the breach. So the matter came to court, UK court, and Mr. Justice Fraser had to analyse this point. Mr. Justice Fraser looked at all the case law, and there is quite a lot of case law on this topic before the directive came in. Most of the case law is 2012, so well before the directive came in. We then have the directive with the clause I have just read out to you, which seems to be very clear. Mr. Justice Fraser analysed all the authorities, read the text, and still favoured the opinion in Varney, wherein the judge has indicated that there is nothing there to support a general obligation on the contracting authority. The judge has taken what is called a purpose interpretation of the articles. Now, English judges, like Irish judges, would normally have a literal interpretation. What does the word say? However, this is European law. And at the end, in European law, it's the European Court that will decide. And it has been agreed that the European Court will apply the French purpose interpretation. And that's the only way I can read the judgment, is that the judge has used this purpose interpretation and has said that there is nothing there to justify it. It would give a way too big a burden on a contracting authority having to investigate abnormally tenders at each stage. So the judge, obviously being a trained UK lawyer, wants to get some articles, and he goes back to a recital in the directive, and it's the recital 103, which states that where a tender is abnormally low or appears to be abnormally low, that might be based on technical, economical, or legal unsound assumptions. If that is the case, then you have to investigate. But the recital 103 says where the contracting authority has not received sufficient information, it should be entitled to reject the tender. It doesn't say it must reject, it says it should be entitled to reject the tender. That's in the recital 103. If you go further in recital 103, it says, but if we're dealing with social, environmental and labor law issues, you remember what I talked in the beginning, if we are in that situation, there is a mandatory requirement to reject the tender. So recital 103 helped the judge. That must be a real relief for you, contracting authority. You have no duty, no general duty to investigate. However, if you want to reject a tender, you cannot just reject the tender simply. You must ask the question. You must ask why the tender is so low, because there might well be a reasonable or a feasible explanation why the price is so low. In this context, you should always remember the self-declared judge in Mad America called Roy Bean, where he always said, always give them a fair trial and then hang them. Now, the interesting question in all of this is what can be asked? How far can the questions go that you can ask before you reject or maintain the tender? Let's pause here for a moment, because all of this is quite interesting, but what's all the fuss about? I mean, when will a contracting authority say to a tenderer, sorry, your tender is too low. It is too low, so therefore I will reject. Why would a contracting authority do so? How can a contracting authority explain that to the boss? How can the contracting authority explain that to the taxpayers? Why would you do this? Wouldn't you be happy if the price is very low? So why are we talking about it? No, I can hear you, the lady there in the back, I can hear you saying that, of course, you could be concerned that the person might not be able to finish the job. There is a risk there that needs to be addressed. And you have a valid point if you were thinking that. But is that not something you should have addressed in the beginning when you were putting together the tender documents, when you were designing the tender documents to make sure that only people that have that are economically and financially robust goes forward, that you would ensure that you would have all the guarantees, performance bonds, insurance, all of those aspects? Would you not have expected that the only people that can deliver the job would have passed? Again, I can see you in the back there saying that it is obviously the adequacy of remedies is not obviously sufficient to justify the continuity of services. You're right. But at the same time, is this not something you should have addressed before? Is the whole fuss about the fact that you might like to kick out a tender because you simply don't like the lowest tenderer? Or if you don't like the lowest tenderer because he is what they call a claims contractor, and you're afraid that the claims contractor will expose the fact that your scope of services, scope of works were not very well developed. Is that the reason why perhaps you might like to kick someone out because they are abnormally low? If that comes out, you're in fundamental breach of public procurement law. That is absolutely not entitled. Abnormally low tender, I've told you, is not defined, and it's not defined for a reason. It's not defined to give you full flexibility. But case law has developed that an abnormally low tender is a tender that is not reliable, not serious, not genuine, not viable in consideration of the subject matter of the contract delivery. Okay? Some will say it is the right thing to do to have a pre-agreed estimation of what would form an abnormally low tender. Others would refer to the European Commission and say the European Commission has given a statement that that would be a good idea, that you would determine that in advance. I would strongly advise against this in the strongest possible term. Flexibility is the most important thing you can have as a contracting authority. So if you're going to do all that extra work, you will have to use it. So you're better off not to use this and not to be bound by it, would be my advice. You don't have that obligation. Questions you can ask. The directive gives us a few, but you can ask plenty more. You can ask about the economics of the manufacturing process. You can ask about the methodology. You can ask about technical solutions, originality. What advantages do you have on other tenders? You can ask if you did comply with social, environmental, and labor law. You can ask all those questions. But that's where it becomes interesting. Can you go further than that? Can you ask a contractor, how come the prices he has made are so cheap? You probably know that when you go out to tender, you will describe the scope of service and you will describe the scope of works. You probably know that there are gaps in there because you're not an expert in drafting those documents, which are fundamental. What does a contractor do? The contractor, and I've seen it in action, it's absolutely spectacular. They have spreadsheets and they will analyze every single word of your scope of work and they would put a price against it. Okay? But what you don't see is that there is another column there where they say you've asked for A, but you've forgotten to ask for B. So that's a point that they know will be extra money for them, what they call a variation. Now, at the end of the whole exercise, they know what the job you've asked cost, let's say 10 million, but they know that there is minimum 4 million variations there. They won't tell you that, but they know that that will be the case. So they will tender for the job, and they might tender for the job for 6 million, because they know they'll get the 4 million at a minimum back from you. Is this an abnormally low tender? Maybe. It's up to you to decide if it is an abnormally low tender. But can you start asking questions out of your sloppiness, out of your not having done the work well? Can you recoup that and ask all those questions now on foot of an abnormally low tender pretext to get that information? I don't think you can. That would be a step too far. And again, it comes back to the one aspect I've said all along, and I will repeat in all the talks I will give. It is important that your tender documents are wrapped around the project that you're procuring. Wrapped around. It has to be a bespoke tender document. You cannot have standard forms. And I know the OGP are telling us we have to use standard forms of tender document. I strongly believe this does not work. But some of you might say that I might turn into a Miguel de Cervantes, Don Quixote de la Mancha. But remember, on his deathbed, Don Quixote uttered those words, "For neither good nor evil can last forever." And evil, the standard forms we have to use, has lasted for a long time. So good flexibility, perfectly drafted tender document must be close at hand.